thing. Well, afternoon, everybody. Thank you all for turning up. We will try and crack on through this relatively quickly because I know several of you are wanting to shift over into the Housing Summit as soon as we can. So if we can start off with any apologies. Do we have any apologies?
Sorry, we have apologies from Councillor Wilkins.
And do we have any declarations of interest? I'll take that lack of movement as a no. Minutes, I hope you've all had a chance to read them. Are we all happy with those as a true and accurate record? If not, are there any comments? Okay. Sorry.
Happy to propose?
Yeah, okay. Okay, all those in favour of taking those? There we go. Minutes of licensing subcommittee meetings. We've got one from the 23rd of October. Everybody happy with that? Was that me or you who did that one? I haven't actually read the minutes. All right, well in that case I'll propose that as a true and accurate record. Anybody got any comments on that? If not, we all happy with that? Yeah, okay. Right, okay, on to substantive matters of the meeting. Hackney carriage and private hire licensing fees and charges. Who's introducing this one? You, Dave? Yep.
Thank you, Chair. I'll try and keep it brief because I know members are keen to get to another meeting. So members, you'll be aware that each year you set fees and charges for all of your licensing services as part of your budget. Some of these fees are set centrally by government. For example, the Licensing Act 2003 fees are set centrally, and sometimes you have a maximum level at which you can set them. So the fees are capped, as in the ones under the Gambling Act 2005. In all cases where the authority can set fees, there's a general requirement that the regime should be self-financing, but shouldn't be used to generate a surplus or a profit to subsidise other licensing regimes. With your taxi licensing fees, there's a further requirement that any proposed increases in relation to vehicle and operator licence fees need to be advertised by placing a public notice in a local newspaper. Now, since April 2022, this council has operated a scheme whereby those who are applying for licences for vehicles that are fully electric or powered by hydrogen fuel cell are exempted from the requirement to pay licence fees. So that's been in place for at least 2 full years now. And at the time I prepared the report, you licensed in total 490 vehicles, 60 Hackney carriages, 430 private hires, of which approximately 2% were fully electric and therefore taking advantage of that waiver scheme. On the basis that the overall numbers of applications remains low, it is our recommendation that the fee waiver scheme can continue for a further year to provide that as incentive to drivers to make the transition to fully electric vehicles going forwards. There are, however, some proposals to increase the fees the council charges in respect of Hackney carriage and private hire licences, and the proposed fees are at Appendix 1 on page 51. Members, you're asked today to note those proposed fees and charges, and that some of these will now be advertised in the local newspaper with a view to their inclusion in the council's fees and charges for 25-26. And members, you're also asked to recommend to council that the fee waiver scheme currently being operated in respect of applications to licence those vehicles that are fully electric or powered by hydrogen fuel cell continues for a further year, with that situation being reviewed again in 12 months' time.
Thank you, Dave. Eric?
I'd just say I've seen the charges. They're broadly in line with inflation, fairly modest, and I think the idea of keeping the electric vehicle business free is worthwhile. So I'm happy to propose.
Okay. Any other questions or comments on that? No? It seems we are all reasonably happy with those charges in that case then. I'll take that, put that to the vote then. All those in favour? That's all of us, I think. Okay, that's nice and simple, but then I suppose fees are a relatively simple thing to deal with. Okay, so in that case we're moving on to the next item, which is the consultation on draft policy on pavement licensing, Dave.
Thank you, Chair. Again, this is an item that was before this committee fairly recently when you approved a draft version of this policy for the purpose of consultation. So in the interest of brevity, I won't go through the history of how we came to have pavement licensing. I'll focus more on the process that's been followed since you considered the draft pavement licensing policy in July. We conducted the consultation on that draft version between the 19th of August and the 30th of October, and we facilitated consultation using an online survey tool that asked respondents whether they agreed with the content of the draft policy in respect of the requirements when making applications, those who'd be consulted on applications, the approach the policy sets out to determining applications, the standard licence duration, the standard conditions that will apply to licences that are granted or deemed to be granted, and the approach that the Council proposes to take to compliance and enforcement activities. And where respondents didn't agree with any part of the policy, they were asked to provide some further explanation and context to those answers. We also provided an opportunity for respondents to make any other comments or observations that they had. At 4.19 of my report on page 57, you'll see the group of organisations that were directly contacted with a copy of the consultation survey and the background information. We also included a link to the consultation survey on the consultations page of the Council's website and publicised it via social media channels. In total, we received, there were 12 people who responded to one or more of the questions that were asked, although only 7 respondents stuck with us to the very end of the survey and answered every question. And we've provided for you at Appendix 1, pages 61 to 66, a summary of the responses that were received, which hopefully you've had a chance to go through. I don't propose to go through those in detail unless members have any particular questions about anything in there. It is fair to say the majority of respondents agreed with the content of the draft policy. However, we have considered some of the comments received from various respondents and as a result have made a few changes to the draft policy. Firstly, Evesham Town Council expressed a wish to be notified of applications, and we don't think it's problematic to include town and parish councils when circulating details of the applications that are under consultation. This is something that's been asked for in Bromsgrove District Council's area as well as part of their policy consultation, and is something we've included there. So it seems to make sense to include town and parish councils. We appreciate that given the tight timescales for responding to applications and determining them, it might not be possible for them to respond to every application, but at least if they are receiving them, they all know who has and hasn't applied, and they might, if the timing is right, have a chance to comment on them. And they may be able to put some sort of system in place for considering applications outside of their normal meeting cycles, because I appreciate that those don't come round all that often. So yes, paragraph 4.3 of the draft policy has been updated to include town and parish councils, the relevant town and parish council, in the list of people who will be consulted on individual applications. One respondent suggested that any review of safety, fitness or position of the furniture should be the responsibility of the council alone. And whilst we agree that the final decision rests with the district council, we have the licensing function. It is our responsibility to make those decisions. We do think it's important to consult and consider the views of a wide range of other key stakeholders as are set out in the policy, particularly important being the Highways Authority and the police in respect of road safety and pedestrian safety. One respondent suggested licences should only be granted for a maximum of 1 calendar year. We believe granting them for the maximum 2-year period will reduce administrative and financial burdens both on the businesses and the licensing authority. And members, we would remind you that if there are issues after a licence is granted in respect of placing the furniture on the highway, the authority has the power to revoke the licences where the circumstances justify it. So the fact the licence is being granted for 2 years doesn't mean that it's then not possible to deal with any issues in that 2-year period. One respondent suggested that the conditions of pavement licences should make clear that advertising is not permissible without advertising consent from the planning department. We are mindful it's not best practice for licence conditions to duplicate other legal requirements, so whilst we haven't included it amongst the standard conditions, we have added a further paragraph 11.2 of the draft policy to highlight for applicants that those who are applying for licences should seek advice from the planning department in respect of any advertising consent that may be required, and to provide signposting to the relevant page on the council's website. Another respondent has suggested that excuse me, that the standard conditions should direct an applicant to a council or town design code and ensure that any furniture placed outside of the premises falls within the parameters of that code. We believe that would be overly complicated and not necessary or proportionate, and that each application ought to be considered on its own merits rather than being constrained by a particular design code. Depending on the nature of the business, the type of furniture they want to offer might vary, and what might be suitable in one area might not be suitable in another. So I think you've got to look at each application on its merits. Two respondents commented on our proposed approach to compliance and enforcement. One felt that insufficient compliance and enforcement activity had taken place so far, and another felt that routine inspections need to take place to ensure businesses are complying with their requirements. Again, we believe the approach set out in the policy is reasonable and is proportionate. Visits have already started to take place to towns and villages right across Worcestershire to try and identify those businesses that are putting out furniture without a licence and engaging with the owners to highlight the requirements and to put them on the right track in terms of applying for a licence. This work will continue, and once the draft policy has been approved here and elsewhere, our efforts on that regard will be further ramped up ahead of the warmer weather returning in spring next year, when we'll be looking to make sure that everyone who's got furniture out has applied for a licence. Finally, Evesham Town Council requested that a list of issued pavement licences should be made available on the council's website, and we're going to look at ways we can make a public register available for everyone to view online of all the pavement licences issued. So, having considered the consultation responses and having made some amendments to the draft policy as I've just gone through now, members, you're asked to recommend to Council that the draft policy on pavement licensing shown at Appendix 2 be approved and adopted.
Okay, thank you, Dave. Do we have any comments or questions on this, particularly on the consultation responses received and the changes made to the draft policy as a result? Nicola?
Is it possible, how would can people report businesses they think that haven't got a pavement licence but they are, and is it obvious where to find that information or how to report it?
Yes, in terms of there's the same way that anyone would report any suggestion that something that needs a licence hasn't got it is contacting ourselves at WRS, and we would then obviously follow that up. We've had certain people who've got pavement licences. If you've paid for one and gone through the process and you see somebody down the road who hasn't, then they are already bringing that to our attention, and we're following those things up. So yeah, that's how they would go about it. Again, we could look to raise public awareness a bit further off the back of perhaps council approving the new policy. It could be an opportunity to put some sort of press release out, which could do two things. It could help highlight the requirement to get a licence to those that need one, and also help highlight to those that might want to report what they think is a breach or want to check whether something is licensed, how to contact us to do that. So we could use the opportunity, having adopted a policy, to put out some press at the correct time, so that we can raise awareness more broadly.
Yeah, I do think that having a list of them online will help in that respect, because it will make it fairly obvious who is licensed and who isn't, and then having found out that somebody isn't in the list, they can then be directed as to where to go to suggest that they get a license. Liz?
Yeah, I can't remember. If there isn't an actual road, it's a sort of an internal square without a road on it, do they still need a licence?
The key thing is whether or not it's part of a relevant highway. That's how the legislation is worded. And in terms of what is a relevant highway, it makes reference to highway to which Part 7A of the Highways Act 1980 applies. Now, that is very obtuse in some ways, and we find it difficult because we make assumptions sometimes that something is highway and it's not, and vice versa. So what we tend to do is have reference to the County Council's mapping tools online, where they show the extent of the highway, but those maps are not absolutely accurate in terms of exactly which square metre is a highway and which isn't. So we then liaise with our local highways liaison officer, which in this area is a chap called Barry Barnes, who is able to hopefully assist us in determining whether furniture that someone's placing outside is on a relevant highway or not. Because if it's not, they don't need a licence and we shouldn't be taking any money off them. And if it is, then they should have a licence. So it is a little bit of, we're taking, with the compliance and enforcement approach we're taking, it's very steady. We'll go in and we'll get our facts right first, make sure we understand what we're talking about before we engage, because there's nothing worse than telling someone they've got to apply. They go through all the hassle of making the application, paying the fee, and then we consult highways and they go, that's not the highway. So we do that bit first, make sure we know what we're talking about before we dive in, and then, yeah, we can advise people accordingly. So again, it is a little bit of a case of each case on its own merits, looking at where it is and coming to a judgment. So the example, it's not a Wychavon example, but the example I'll use is in Worcester City. You've got parts of the Crowngate shopping centre in Worcester appear to be streets. Lots of people walk along them, they're open air, but in fact they're part of the shopping centre, and so they don't require a pavement licence in there. So if you know Worcester, there's a little row between it's between Primark and Boots, I think, and you've got 3 or 4 restaurants there, all of which are putting out quite a lot of seating, none of which requires a pavement licence because it's not on the highway. And yet, places on the high street, even though it's pedestrianised, that is the highway and they do require it, so we've got licences in place there. So it isn't always as obvious as you might think, but we do look at it very carefully and try to make sure that we give the correct information out to people when they come to apply.
Okay, any other questions, comments? No? It all seems relatively straightforward. I mean, I take your point about the difficulty of knowing where the highway is, but as I understand it, it's exactly the same definition of highway as applies to other law like parking and things like that. So it has to be consistent across the board. And sometimes when you've got pedestrianised streets and things like that, it's not always obvious. But so long as somebody knows and can tell us when we need to know, that's what matters. Yes. Okay. Well, in that case, unless there are any other comments, I'm happy to propose from the Chair that we take this forward and recommend the draft policy to Council, taking into account the amendments following the consultations. Anyone want to second that, Liz? Okay, all those in favour? Right, that is clearly carried. Okay. Right. Next thing we have got to do is Tobacco and Vapes Bill, a verbal report.
Thank you, Chair. Again, I will keep this fairly brief because there's only limited amounts that I'm able to provide with any great clarity on anyway. So, members, the government introduced its Tobacco and Vapes Bill into Parliament, and it had its first reading on the 5th of November, and it had its second reading yesterday in Parliament and was voted through that stage. And so now will continue on its way. The Tobacco and Vapes Bill is largely based on a similar bill that was before the last Parliament, prior to the general election, and brings forward many of the measures that were contained in there, along with some new ones. The key things for you to be aware of in terms of your role as a licensing authority are that the bill provides powers to government, or will provide powers to government if it becomes law, to expand the current indoor smoking restrictions that are in place to certain outdoor public places and workplaces. There was much in the press about whether the government were intending to increase the smoke-free outdoor places to include things like pub beer gardens and other similar areas. They seem to be rowing back on that, but they are still considering making certain smoke-free places, such as outside of hospitals, schools and children's playgrounds, but they have specifically said that they're not looking to do it in respect of outdoor hospitality settings or wider open spaces like beaches. So that's one important power that they have, which would impact in terms of your licensed trade. It also provides powers to make places that are currently smoke-free also vape-free. So at the moment, although you can smoke, though you can't smoke in a pub, you can, if the publican will allow you to, vape inside a pub. The government are looking at making it so that the same restrictions apply whether you're smoking or vaping in those indoor spaces. Again, that's within the bill. They're also looking to strengthen enforcement activity around the sale of retail sale of tobacco, herbal smoking products, cigarette papers, vapes and other nicotine products. And part of that is provision in the bill that will give the Secretary of State the power to introduce a licensing regime for the first time in England for those that sell those sorts of products, those relevant products. There'll also be a registration scheme provided for those that sort of supply them on the wholesale market. But in terms of the retail sale of tobacco-related products and vapes, there is power within the bill to introduce a licensing requirement. At this stage, we don't know which level of local government the licensing function will fall to. The impact assessment says that will be decided later following consultation. Obviously, there's clearly a long-standing role for trading standards, which is a county council function in respect of dealing with the sale of tobacco products to either people who are underage or the sale of counterfeit and non-duty paid. You may have seen fairly recently in the press a huge haul of illegal tobacco and vapes taken out of a shop in Evesham. That sort of activity is going on all the time already. But they're going to increase the powers to issue fixed penalties for those offences, and they're going to look, as I say, to bring forward a licensing regime in due course. So that may be something that falls to the District Council to administer. It may be that it sits at the Weights and Measures Authority, the County Council, from a trading standards perspective. But in due course, we'll know a little bit more about what that looks like. And the big headline, which I haven't mentioned, but is actually probably line one of the bill, is the intention, again, which was included in the original version of the bill in the last Parliament and it remains in this one, to essentially phase out the ability for children who are born on or after the 1st of January 2009 to ever legally purchase tobacco products. So the intention is to create an entire smoke-free generation in due course by setting a date on or after which people born cannot purchase those products. And that is retained in the bill. And as I say, the bill passed quite comfortably through its second reading and is now off to the committee stage when various amendments will be discussed and put forward, I'm sure. And we will provide further updates to you in due course when there's a bit more clarity around the role that this particular local authority will play in any new licensing regime.
Okay, thank you. Are there any questions on that? Bearing in mind that this is really just a running commentary on a process through Parliament, so there's no decisions we can make at the moment. Nicola?
Just a quick one. Did the disposable vapes figure in it at all?
I'm just going to check. I've got a feeling they've already made a decision to ban disposable vapes outside of this bill. I think there was a separate secondary legislation passed that will ban it, I think, from next April. I can check for you and come back to you. But I don't think that was specifically included in this bill because I think it was done separately under other powers. But you're quite right. They are looking at banning certain flavours, colours, packaging, etc. as part of the tobacco and vapes bill that's before Parliament. To try and effectively make it less attractive to children who are starting to vape having never smoked, which is the key concern, I think, around vaping at the moment. And whilst there's recognition that it's better for you probably than smoking, and it's a good way of stopping smoking, if you are looking to stop smoking, it can be a good transition to stopping you from doing so. There's a great deal of concern about the number of young people who are getting hold of vapes, particularly the cheaper disposable ones, that are available very widely at the moment in lots and lots of stores, places that wouldn't dream of selling alcohol. Here we go. Jen's very helpfully done some Googling. Yes, the sale and supply of single-use vapes in England will be banned from the 1st of June next year. So that's already been passed, I think. I'm not sure what legislation that was passed under, but that's happened and isn't within scope of this bill, although they are looking at things like packaging, flavours, etc. And the licensing regime as well will impact on those that sell vapes. Without the disposable ones, I suspect there'd be fewer premises selling them, to be honest, because it's not as convenient to sell the non-disposable ones as it is the disposable ones. But will remains to be seen, I think. But a lot of hurdles to get through before it gets through Parliament, and then in terms of implementation, there'll be lots of consultation, I'm sure, on the secondary legislation required. So it's not imminent by any means, but it's just putting it on your radar as something that is moving down the line towards us in due course.
Okay, any other questions, comments? Yeah. Okay, well, that's just for noting, so thank you very much for that, and we'll look forward to hearing more as and when it comes forward. And the final item on the agenda is the Licensing Committee Work Programme, which, again, we are most merely asked to note, but is there any comments on that before we note it?
My only comment is that the CCTV licensing Hackney carriage and private vehicles, it would have been useful had it been involved in with the case we've had today, but that's all I'm going to say.
Well, maybe in future we will find that useful for subsequent licensing subcommittee hearings, but we'll leave that for the time to come. But otherwise, we're happy to note this. Good, okay. Well, in that case, that is it. So you've just about got time to Zoom next door to be in the Affordable Housing Summit. Thank you all for coming.